Africans asking themselves if the Oscar Pistorius trial is indeed a fair trial. Now, to break down the legal part of the case, we are now joined from our Cape Town studios by the Executive Director of the Justice Alliance South Africa, John Smyth. John, good morning to you and welcome to AM News.
Good morning, Elvis. Thank you for your invitation.
Now, John, the Oscar Pistorius trial, it has revealed a level of quality of the legal process that the criminal justice system is capable of producing. Going forward, do you think that the same will apply to ordinary courts in the country?
Well, I think it may do, but I think, may I just question your initial remarks? Because it seems to me that we have a big question to answer here. It's a paradox, really. Have we been putting on a good television show, turning the court into a studio, or have we been doing justice, or have we managed, as we all hope, to do both? Now, I think it's very difficult. I was in England when this case started, and of course my background as a lawyer is the English courts. I practiced for 20 years as a barrister, that's an advocate in England. I was Queen's Counsel, the equivalent of senior counsel here. And then I sat as a judge for 5 years, a part-time judge. And I have to say that the feeling in England amongst my old friends there, my old friends and colleagues, was that there were two difficulties with this trial. Mm-hmm. One, that it was a very difficult trial to handle, and the judge should have kept everything on a much tighter rein. You know, the trial of this sort is a pretty unruly animal at the best of times. It's worse when you've got television cameras there and this whole question of whether witnesses want to be seen or heard. And I think that for justice to be done, we should have seen her not only being entirely impartial, as undoubtedly she was, and she came through very well on that level, undoubtedly, but I think she should have kept the advocates on a much tighter rein. And I also discovered in England, and I must say I respectfully have to agree with my colleagues there were letters to the newspaper about this, that the style of advocacy which the criminal advocates adopt here in South Africa is perhaps not the best. It certainly wouldn't have been acceptable in Britain when I was an advocate. And what I mean by that is the rather abrasive, confrontational style of both advocates. I was taught that advocacy was an art, and one very gently and very quietly, without ever raising one's voice, blocks off the escape holes for a witness, or particularly an accused, and then puts the nail in with the vital question. And I'm not sure that we saw that happening. I think it was all too confrontational. Witnesses were frightened away, we were told yesterday by Barry Roux.
Mm-hmm. Now, you mentioned the words confrontational and abrasive, but isn't it maybe because the trial was televised and it actually pushed both sides to just work a little bit harder, though?
Well, if it was simply to work a little bit harder, then of course we mustn't quarrel with it in any way. But if it was to put on more of a show, then I think we want to think twice before doing this again. I know they've done it in America. See, the rule in Britain is that the television cameras are there for appeals, but not for trials, because I think the feeling is that it's too much for a witness and an advocate to carry on with the job in the best possible way without being conscious of the cameras. And there's always the temptation to put on a show. So certainly I agree with you. If it helped the advocates to work harder, excellent. If it helped them to put on a show, as I rather fear we saw sometimes, then it's a pity.
Now, you mentioned also scaring the witnesses. Now, we've seen both Advocate Barry Roux and Gerry Nel tenaciously laying bare some of the inconsistencies in the witnesses' testimonies. Will this have a negative impact or bring fear, rather, for people who would want to testify in other court cases?
Well, I'm worried that it may. In the Justice Alliance, for whom I work, we do a lot of civil litigation, and we are fortunate to have advocates who appear pro bono for our work, because we're a charitable organization. Now, these advocates who appear in the civil courts are excellent, but their style of advocacy is quite different. They would never pick on a witness and badger a witness in the way that particularly Nell did to try and get him or her to change his story. I don't think that should happen. I think it will frighten away witnesses.
Mm-hmm. Now, if you think about it, John, if we look at the Oscar Pistorius trial, do you think that, on the other hand, though, it educated South Africans on how the actual justice system works?
Yes, good point, if I may say so. I think it's very good for the public to see what goes on. I'm only concerned as to whether we really did do it in the best possible way.
Mm-hmm. Now, many have said that the
trial...
Continue, John.
Can I give you an example? Mm-hmm. Can I give you an example? You see, if I were cross-examining Pistorius in this case, I would have very quietly have asked him questions and made him feel comfortable about his gun and how powerful it was, and the fact that, of course, he knew it would shoot through a wooden door and one shot could kill a person, and so on. And then very quietly I would have said to him, now, Mr. Pistorius, is your defense one of self-defense? And we would have got some sort of answer to that, and I would have said, well, if it was self-defense with a gun of that power, just tell us why 4 shots? Wouldn't one be enough to deter the burglar? And then he might have said, well, it was all an accident. And then again, I would say, Mr. Pistorius, tell us, how can it be an accident to pull the trigger 4 times? In a very low-key sort of way. Those are the powerful points, I think. Mm-hmm. Not badgering a witness to change his story. I don't think we should do that.
Mm-hmm. Now, Gerrie Nel, they call him the bulldog. Now, he has been the main prosecutor representing the state's case.
Yes.
If you look at our Justice Department, are they grooming other people, do you think, who will make one day or take the reins over from Gerrie Nel, who is a very great prosecutor, some might say?
Well, I imagine they are. I just don't know. I'm not in a position to answer that question, because I don't go into the criminal courts at all, really, with no exceptions, I was going to say, as a rule. Mm-hmm. So I don't know, but I imagine they are. But I do hope that there is room for a different style of advocacy, the sort of style of advocacy which I would encourage. I was always taught advocacy as an art. It's not a fight.
Mm-hmm. I want to just go back to my very first point, John, when we talk to access to justice and equality, really, in the justice system. Now, many would say that this trial was basically showing the world how the justice system actually works, but there is still inconsistencies in terms of who can actually get a free trial. If you have the money, you can do it. If you are poor, you do not get the same. Do you agree?
Well, I think there's a very real danger of that, particularly in our country. On the other hand, we do have a good legal aid system. It doesn't work particularly well at the level of appeals. I know that, because in the Justice Alliance we're constantly getting calls from prisoners, faxes from prisoners, saying, please help me with my appeal. The legal aid authorities aren't doing anything. But I think it works pretty well at the trial. Mm-hmm. I do think the representation which the state provides at the trial stage is usually adequate. Not to say it's always brilliant. Obviously, the younger members of the profession will do the legal aid work usually, except in an exceptionally heavy case. So it's not perfect, but I don't think it is in any country.
John, lastly, what can we expect in future? Are we likely to see more trials being broadcast?
I think there will be a pause while we consider the position in respect of this trial. You see, quite rightly, although we haven't talked at all about trial by media, but one of the things I have been greatly concerned about is the freedom which the press have been given to discuss this case. And it started way back at the time, of course, of the bail hearing, when some of the issues were raised by the magistrate himself. and the discussion began then. It would never happen in England, primarily because we have juries. But we seem to have lost sight of the fact that not only does a judge decide, but she has two assessors. And those assessors have an equal vote on the question of guilt or innocence. So when the press say all the time, Pistorius' future is in her hands, that's not right. They could outvote her, those two assessors. And they're ordinary people. They haven't got the training a judge has. And is it right to expect them to put aside everything they inevitably are going to see in the press, see on TV, read hear on the radio? I mean, it comes at us from all directions. And I think we do need to consider the rule which we have in respect to prevent trial by media. It's called the sub judice rule.
Mr. Smyth, thank you so much for your time.
Pleasure.
That was John Smyth, the Executive Director of the Justice Alliance South Africa. Moving on to other stories now. Metro Rail in Durban has assured passengers that the rush hour this morning will not be affected by last night's accident. About 80 people have been injured when two trains collided at Berea in Durban. Metro Rail says it will fully investigate the accident.